The second part of this seminar is dedicated to a central topic for this course, that is, what are the constituents by which we specify norms, policies, or other forms of directives. The term normative system can be interpreted in two ways. On the one hand, a normative system is a system of norms. Norms are used as basis to legitimate conclusions, and therefore they support the constructions of inferential meaning. On the other hand, a normative system is a system whose autonomous components are guided by norms. Under this view, norms provide guidelines on how the interactions between those components should or should not occur. The classic way to specify norm is by means of some form of deontic logic, or the logic of obligation, prohibition, and permission. According to the classic axiomatization, if a person has the obligation of A, she has also the permission of A. On the other hand, if A is prohibited, that means that A is not allowed. I will not enter into all the discussions still ongoing related to deontic logic. I will just observe that there is no explicit presence of the word right in the terms of deontic logic. Yes, specifying rights and duties is what we commonly see to be the sense of writing contracts, laws, and any form of paralegal document. So how to fill this gap? It was the American legal jurist Hoffeld, 1 century ago, that observed that the term right is highly ambiguous. Everybody uses it without really realizing the difference in meaning. The first meaning is right as a claim. For instance, I have rights over this land. A tribute or a rent has to be paid to me. A more modern example is renting an apartment. Finally, we still call the owner the landlord. The second meaning is right as a permission, or better as a protected liberty. For instance, in a dedicated smoking area, I have the right to smoke. That is, nobody is allowed to interfere with my act of smoking. Another example is the freedom of speech. Nobody is allowed to interfere with someone who wants to publicly state his opinion, with some limitations. The third meaning is right as a power. For instance, if you have some special car insurance, you have the right to request assistance. That means you have the power to create a duty upon the insurance to give you assistance. Another more traditional meaning of power is the ability given to kings, commanders, official directors. They are entitled to create duties, to some extent, upon certain groups of people. The fourth and last meaning of right is as immunity. For instance, if you have diplomatic rights, this means that you are beyond the jurisdictional domain of the country in which you're in. If a public officer commands you to open your luggage, you're entitled not to follow him. The normal power of the officer is disabled against you, as you have immunity, yet you could still follow his orders if you wish. So far, all seems reasonable. So it is true that this ambiguity is so frustrating in practice. I will bring two examples, told by Rejka Markovic a few years ago. The first is from a European Minister of Justice. The argument, if I'm not wrong, was about the right to marry for homosexual couples. The minister said, "It's ridiculous to say that the right to marry is a human right. It would mean that the state has the duty to find a wife for those who don't have one." This sentence shows that he was reading right as a claim, the first meaning. A more common view on the right to marry is in terms of power. The state has to recognize two people who got married. And has protected permission. Nobody should interfere with someone's will to marry. In another moment, in the same country, a president of the Constitutional Court explained a certain rephrasing in the Constitution. The Republic guarantees the right to property to everyone was changed to everybody has the right to property, because the former would follow that goods should be divided equally among people. In this case, the president transformed right as a power, or as a claim to have property, to right as a protected freedom. Now, let us return to Hoffeld. Hoffeld observed that primitive relevant normative concept can be illustrated on two squares. Each square shows the relationships holding between two parties. He observed these relationships in actual court cases. On the obligative square, if you have a duty, this means that a counterparty has a claim over it. On the other hand, if you are at liberty with respect to that action, it means that the counterparty cannot claim anything about you doing or not doing it. Similarly, for the second Feldian square, also known as the potestative square, if you have the power of A, then someone is subjected to the performance of A. On the other hand, if the other person is immune to A, then you are disabled to use that power. In other words, normative relationships are about someone's being allowed or disallowed, first square, or enable, disable second square to do or not to do something that interacts with the interests of someone else. With respect to enabling, we are not talking about physical actions, but institutional actions, actions that modify someone else's allowances or abilities or their negation. This explains why the obligative square is also called the first order, and the potestative square is called of the second order. Positions of the second square defines how those of the first can be or cannot be modified. Given this framework, we can consider a series of causal patterns. A position of power, if utilized, will generally be used to create a claim. A king commanding creates duties upon his subjects, and so he will have claims towards them. A position of duty, if not satisfied, will become a liability to be punished. Plausibly, a duty without some form of enforcement will not be sustainable in the long term. Everybody will start cheating, not following the duty. In formal institutions, the power to enforce for an official emerges only in the moment in which a violation occurs. If you drive beyond the speed limit, you may receive a fine from the police. A position of immunity will typically develop into a privilege. The case of diplomats is paramount. We see immunity in action when someone is attempting to create a duty upon the party who has such an immunity. So, for instance, if everybody has to go below a certain speed limit, diplomats are free not to abide by this rule. Privilege in Latin means without the law, in the sense of outside, beyond the law, to which all the others are subjected. We can also identify an additional distinction between first and second square. Duties, prohibition, and freedoms concern a word of ideality, where ideality is here to be interpreted simply as a word whose participants follow the norms. Powers concern instead the more practical view of how the social system attempts to reach this ideality. We will return to this later in this course, but let's consider a general template of how norm functions. There is an ideal. The ideal is supported by an adequate reward structure. Even more concretely, agents are given with instruments, powers, to implement the desired reward structure. An example. As an ideal, you have to behave well. As a reward structure, if you don't behave well, you will be punished. As a power structure, if your mother decides that you haven't behaved correctly, she will prohibit us to bring you with us to play. Note that mother has here two powers. One is to conclude where behavior is correct, the other one is to constrain us to perform certain actions. A similar decomposition can be found also in methodologies for requirement engineering. Ideality goes with goal modeling, responsibility attribution is about assigning role to parties, operations is about what part of the process is performed by whom. We have presented the primitive fundamental normative concept, or as often called them, juror relationships. How these relate to rules. In some cases, juror positions appear explicitly in rules, but implicitly they are always there. Pay attention, sometimes they are not what they seem though. For instance, have to, must, or should is not always a duty. Additionally, rules may contain more than one positional meaning. For instance, the teacher decides when the lecture is over means that the teacher has the power to determine that the lecture is over, for instance, by saying it. On the contrary, the students are disabled to do so. Otherwise, we would have plausibly very short lectures. The directive may also mean that the students have a duty to stay. If not, this power will not serve so much. The lecture is then... no, it's not over. Okay, let's give now a few examples. Paul has to give 100 euros to Mary is clearly a case of duty. John cannot smoke, of prohibition. Anne can ask Paul to give Mary 100 euros is of power because it puts a duty above Paul. Note that in the first case, Mary is the recipient of the money transfer, but she may not be the counterparty of the duty. For instance, if Anne does ask Paul to give Mary the money, it could still be Anne the claimant having interest that the action is performed. This is captured more explicitly in Paul as to give 100 euros to Mary on behalf of John. In this case, John is the claimant of Paul's duty. John can smoke if he is outside is a conditional protected freedom. Note that you could also interpret this as a power. John has the power to gain the right to smoke if he goes outside. The third example is power about transforming the recipient of the action within a duty. The claimant remains the same. One could imagine, however, that there may be a duty of John to give money to Mary that could be terminated by Paul's action. The first case here is subtle. Most people will certainly see it as a duty, but strictly speaking, you don't have to pay if you don't see the film. If you don't pay and you don't see it, nobody will punish you. So the best way to look at this type of sentences is to understand when you would be punished. In this case would be if you see the film without paying. So here you are rather prohibited to see the film without paying, but if you pay, the prohibition is released and you're now allowed to see it. So that sentence is rather a specification of a power removing that prohibition. On a second level, implicitly the directive creates also a duty upon the film provider to show the film to you. This type of power is more evident in the second case. You have to pay to have the certificate. No punishment is involved, only service provision against a payment. The third case follows a similar pattern. The central element is the prohibition of processing without consent. The fourth case is again puzzling. It looks very similar to the previous ones. There is a prohibition, but we know that the prohibition is not released by paying a fine. The fine is a remedy for a violation, whereas in other cases there was no violation. With this we end the second part of this seminar. If any question, please just write on the discussion board.